Good evening, everyone. Welcome to week 10, definitely getting to the business end of the term. This week, we've got our final ground of review that we'll be looking at in this unit. We're looking at unreasonableness, or Wednesbury unreasonableness. It's a bit of an interesting ground of review because it's very broad. It can cover a lot of interesting things, but it is also quite tricky to prove and to demonstrate. So we'll talk through a couple of the nuances of that, and then we'll jump into our hypothetical questions for this week. Before we do that, one very quick bit of housekeeping, and it's in relation to the student unit and teaching evaluations. This is separate from the sort of my experience surveys that I asked you guys to do a couple of weeks ago, which have been really helpful. So thank you to everyone who did that. Those were kind of the rolling, kind of live updating feedback for you guys, so that, there's, things to work on or things to keep doing for this unit. What I'm talking about now is sort of the standard end of term student evaluations that you get asked to do for every unit. And just I guess a general plug to ask if you please can spare 5 minutes to complete those. Those are really important for a range of reasons, and I'll give you a very quick elevator pitch on why you should fill out these surveys. The first, of course, is that it's beneficial for the administrative law unit. It's beneficial to my teaching. It's beneficial to future students because it really helps highlight, the things that are working well. And please, if there are aspects of the course that you are enjoying and that you have liked and that you have found helpful, please do flag that so that, we can keep doing that or do more of that. And then, of course, if there's elements that you think could have been improved, of course, that's your opportunity to anonymously highlight that as well. So that, is, of course, going to be a huge benefit to the unit and to future students. There's also a big benefit to you guys to doing this survey. And that's because it improves sort of your own experience here at CQU. We don't get the results in isolation. As a law school, we sort of talk to each other and we collaborate to see what's been working well, what sort of hasn't been working so well. And so the things that you raise, both good and bad, in this survey, we have a chat about as law school teachers. And then for your future courses that you'll do here at CQU, you'll be able to benefit from that as well, because other people will be able to pick up on that feedback too. And then, of course, if you end up with me teaching you in another unit, I teach a third year unit as well. So you might see me again in a year or two's time. Then, of course, you get a very direct benefit from your feedback as well. So that's my little plug. Please do fill out those surveys because they are really, really important. And then my last sort of attempt to sell you on those surveys is a little promise. I've got here 3 envelopes, and I think the screen shows this backwards, but I've got 30% completion, 40% completion, and 50% completion. If we get 30, 40, or 50% completion of that survey by the end of the week 12 tutorial, I'll release a hint for the exam that corresponds to each of those percent. So if 30% of you fill out the survey, I'll reveal that hint. If 40% of you do it, I'll do the 30% one and the 40% one. And if 50% of you, which would be amazing, fill out the survey, then you get 3 hints for the exam. And, obviously I can't tell you what's on it, but trust me, it will be worth your while to try and fill those out and try and get those hints. So that's my little promise to you. So I'll please do fill those out, and then we'll check in week 12 and look at what the completion rate is, and then you'll get the corresponding hints. So if that doesn't sell you, I don't know what will. But let's jump into the topic for this week, which is unreasonableness. And I suppose the main thing that I want to stress to you guys in relation to Wednesbury unreasonableness is that it's not just anything that you don't agree with. And I think that sort of more than anything, I think with all the grounds of reviews, I think there's a temptation to sort of, at a stretch, we could try this and stuff. And unreasonableness, because it is so broad, and you could argue anything is unreasonable. It is tempting to really overstretch on this ground of review, and I really want to emphasize that that's not the right approach with this ground of review. If you want to, if you want to annoy a judge, argue that something's unreasonable when it's not. You have to be really, really careful and really, really targeted in relation to this ground of review. It's not just anything that we think is unreasonable. It's something that is so unreasonable that no reasonable decision maker would have made it. And so we're talking about things that are demonstrably absurd, that are just completely off anything that would be remotely, okay. And generally you tend to find that as something that's built onto other grounds of review. You tend not to find unreasonableness in isolation. It's usually that there are one or more other grounds of review that we've talked about in this unit, such as, no authorized decision making power, no evidence, things like that. And they sort of all add up to make a decision that's just completely unreasonable. And so I think that's important just in general, of course. It's also important for your take-home paper, because I think that there probably is, in general, there's a temptation to just go for unreasonableness. And that's a risky strategy, because if it applies, then that's great. But if it doesn't apply, you start to look like you don't quite know what you're talking about, because you've gone for it and it isn't really there. So this is why I'm sort of emphasizing, if you're going for unreasonableness, you need to think really carefully. And I think I mentioned this a couple of weeks ago, because this is a take-home paper, the way the grounds of review are assessed a little bit differently to a traditional exam, right? Normally with administrative law exams, what we do is we, give you this scenario, and then, it's sort of how many grounds of review can you come up with in the 2 hours or the 3 hours? Sorry, Zena, can you just mute your mic, please? So, you're sort of limited by the time constraints. But, in 36 hours, you can come up with heaps. And so it's that sort of method doesn't really work so much. And so what I'll be looking for that's different from a normal exam is a lot more careful and considered application of, alrighty, what are the best grounds of review here? And so, where, you'd, in a normal exam, you'd kind of be tempted to just go for unreasonableness in the last 10 minutes, just scroll something out. What I'm sort of cautioning you is, that temptation is still going to be there, but you need to think a lot more carefully about whether unreasonableness is going to apply or not. Any questions about unreasonableness before we go into today's topic, today's questions, I should say?
Jacob, would you say that the Edelsten case would be a good case to, because that's so unreasonable? Like, would that be like a good, mark to sort of say, okay, well, because that's pretty crazy.
Yeah. So I like Edelsten because it's sort of, it kind of hits home a little bit. I used to work in tax law, so it's sort of, it hits home a bit different to me and just sort of shows, this is a crazy area of law to work in. But yeah, it's a good example because it's just so insanely over the top. And then same with Chan, where they just, they looked at the wrong file. And it's just, how could you stuff up that badly? If you're reading a set of facts and that's the reaction that you're having to it, you're just going, just what went on there, then that's a pretty good indicator that unreasonableness will apply, or could apply. If you're just reading through it and you're going, they kind of stuffed up a bit, then it's probably not going to cut it. And that doesn't mean that there won't be other grounds of review. Not every problem which gives rise to another ground of review is necessarily going to be unreasonable. And that's the really important thing to keep in mind, is that you could have a breach of procedural fairness, say, and that could invalidate a decision. But if there's some sort of plausible explanation for the breach of procedural fairness, say, then you wouldn't expect it would have been unreasonable. And that's sort of, the key distinction. So Chan and Edelston, I think, are really good cases to focus on and sort of think about as good examples. Parramatta City Council is another one that we talk about in the lecture videos. I think that one probably, is the bar was a little bit lower then than it is now. So it's probably not as good an example these days as say Edelston or Chan or something like that. So if you focus on those cases, I think that'll sort of set you up for to have a good understanding of sort of where the threshold is, where the bar is set for unreasonableness.
Thank you. So if we came across something like that in there, and we're sort of, like you were saying, we were like, oh, I'm not really sure, they made a mistake or whatever, but we don't believe that, we would get it, the unreasonableness argument through. Do we comment on it at all? Do we make a quick, because, acknowledge that we could try and attempt to make this argument, but it's likely that it wouldn't succeed or whatever? Would it be worth doing that?
I'm gonna answer part of that question now, and I'll answer the other part if enough of you fill out the survey.
Oh, okay, fair enough.
but so basically, I think with all the grounds of review, the important thing to keep in mind is that in you giving your advice, you need to be sort of reasonably realistic about the chances of that ground of review succeeding. And so, it's not necessarily the case that every ground of review that's relevant to the scenario will be a successful one. And so, it's possible to say this ground of review, unreasonableness, one of the others, unreasonableness, it is relevant because of X, Y, Z, but we have to be realistic about our chances here, and it probably wouldn't be successful because of ABC. And so, if you did think that there was scope to make an unreasonableness argument, you can make it. But a really good answer would be nuanced enough to show, the court has a pretty high bar for this ground of review, and we probably are not going to reach it in this instance. We'll make the argument and we might get it, but we'll fall a bit short. It's the same thing with what we talked about last week about procedural fairness, how we sort of talked about how, the court will recognize that a procedure hasn't been followed, or the procedural fairness hasn't been given, but they're not going to go so far as to set out exactly what the procedural fairness demands or should have been. Same with relevant considerations. They'll identify that a relevant consideration has been ignored, but they're not going to go so far as to tell the decision maker what all the relevant considerations should have been or how much weight they should have given to them, things like that. So these are all the sort of factors that you should have in the back of your mind to develop a really good, a really nuanced answer. You can identify that something's relevant, but you know enough about the sort of the background and the sort of principles behind administrative law that you can identify, how far the court would be willing to take something or what sort of the likelihood of success is. Does that make sense? Cool. Any other questions about unreasonableness, or I suppose we've moved into sort of the unit in general as well?
Jacob, I look back at our last assessment and it was about merits review, but if we just take one of the things that knocked off her social security claim was that she moved to Gladstone and she had family there, and the Act said that you're allowed to if you've got family in the place that you moved to.
Yep.
meet the test or the bar for something that is so unreasonable. Hey, I had family there. The Act says if you got family there, you can't lose your payment.
Yeah, so you're sort of saying that, the decision was so obviously wrong, the Act is right there. Yeah, I think you could probably make a reasonable argument there. And I think what would really help would be Justice Dixon's quote in Avon Downs, where he said that if the result appears to be unreasonable on the supposition that the decision maker addressed himself to the right question, correctly applied the rules of law, and took into account all the relevant considerations and no irrelevant considerations, that it may be a proper inference that it is a false supposition. So what we'd be saying here is that, if it says it right here in the Act, you can move to be with family. If the decision maker had addressed themselves to the right question, correctly applied the rules, and took into account the relevant considerations, then of course that was the decision that they would have had to come to, and anything else is just completely absurd, completely unreasonable. Then yeah, absolutely, I think that would be, you'd be able to make a strong argument there. And what really helps it sort of, and I don't want to muddy the waters too much, but if you think about the distinction at merits review between a correct decision and a preferable decision, right? A correct decision is one where there's only one right answer. A preferable one being one where there's sort of discretion involved. You could sort of think about unreasonableness in a similar way. It's not an exact parallel, but if something that would be sort of the correct decision at merits review, if it was the only possible, the only right answer based on the legislation and the facts, then if you come up with something that's different from that, then you probably have a pretty strong argument that that would be unreasonable. If there's discretion involved, if the decision maker is allowed a little bit of leeway, then it becomes a lot more difficult to argue that something has been unreasonable, because there's that discretion element. There's that sort of the decision maker has got some room to move, and the court is very reluctant, as we've seen throughout this entire unit. The court's very reluctant to get involved in that wiggle room and tell them how they should, where they should come down on an issue like that. And so arguing that something where there is discretion, arguing that that's unreasonable, not impossible, but it is a lot harder. Cool. Any other questions? Awesome. Alrighty, let's move on to the tutorial topic, tutorial hypotheticals for this week. They're a bit short. The second one's a little bit longer, but a bit shorter. So we should hopefully finish on time this week, or maybe even a little bit earlier. I tend to get a bit excitable, as you guys know, and talk too much. But question one, we're revisiting the aeroplane air operator's license question. And so we're circling back to that just to very quickly ask ourselves, now that we know about unreasonableness as a ground of review, could we argue that could we use that ground of review to help John as well? What do we think?
I was thinking possible lack of plausible justification, just because we'd already established that they hadn't taken into account relevant considerations in that one.
Yep. Yeah, absolutely. And I think, this, the reason I've sort of put this one is to highlight how unreasonableness tends to kind of build off other grounds of review. So you guys all remember from a few weeks ago, we talked about how, the decision maker took into account some irrelevant considerations. They failed to take into account some relevant considerations. And what we're sort of now doing is we're building on that and saying, because of all those problems, the decision that they reached was completely unreasonable. There wasn't a plausible justification, because the justification they gave was based on some irrelevant things, and it failed to take into account some relevant things. Yeah, absolutely. Anything else that anyone would be interested in raising in relation to that question? would you draw a parallel between any of the facts here and the facts from Chan and Minister for Immigration?
Yeah, I thought that they were looking at the wrong hanger,
Mhm.
like looking at the wrong case. But then I thought we had sort of decided that really it wasn't the thing that the decision was resting on, like solely. And if you took that part out, like would that negate the decision, sort of thing? So
Yeah, nice, absolutely. So that's sort of, yeah, that's along the lines of an answer that I'd be looking for here. You'd sort of say the facts here are there are some parallels to Chan in that they've looked at the wrong hanger. The sort of distinguishing factor is that in Chan, that was kind of it. They just looked at the wrong file and everything else just sort of spiraled from there. Whereas in John's case here, they looked at the wrong hanger and that was, you know, a similar problem, but there were also a range of other factors and other bits of evidence that went into their decision. And so Chan may not have the same sort of precedent value that it would to another case, because there is that little bit extra evidence, there is that little bit extra sort of process that would limit Chan's applicability. We could say that you know, all those other factors that did get taken into account were sort of, you know, poisoned by the irrelevant considerations and by the lack of relevant considerations, to sort of say, if we strip all that away because of those problems, all we're left with is the hanger, and the hanger was the wrong hanger, and that's like Chan. So there's an argument there, but yeah, it's really good to sort of point out that there is an important difference to Chan as well. In the chat, Leanne's asked if we could look at capricious use of power due to the bias. Did you want to talk a little bit about that, a bit more about that, or did someone else want to weigh in on that argument and how they might make it? Fair enough. Yep, I can relate. So I'm assuming where you're kind of going with that is that the decision makers sort of harped on about John selling passengers data, and you must be a bad person because of that, and that might indicate to us that the decision maker is biased, which, you know, might be its own ground of review, and then on top of that, it would sort of point to the decision being unreasonable. I think you could possibly make that argument and possibly make that argument quite strongly, on the basis that, yeah, we would expect that a reasonable decision maker wouldn't become distracted by these other problems, wouldn't be distracted by their own bias potentially. And so it's you know, it's something that we might want a little bit more information before we were able to proceed with that. We might want a bit more of a bit more than just a hunch that the decision maker is biased. If we could show that the decision maker was a passenger who'd had their data sold or something like that, that might go a long way, or something like that. But it's certainly within the realm of possibility. Cool. Any other thoughts in relation to question 1? Awesome. All righty. Let's jump on to question 2, which is a new question for this week. And we're talking about Childcare Australia, which is a made-up government authority established to oversee the national curriculum and early years framework in relation to childcare. They're allowed to inspect childcare centres and look at a bunch of things that are going on in the centre. And if there's a problem with compliance with the standards, they can make a note of that, and they can also issue directions to the childcare centre to say you need to do these things to fix the problem. Kylie Smith runs a small childcare centre, and it has 4 staff. They get inspected and they note that the learning resources are not sufficient because there's only 200 books, and that 2 of the staff don't really, their qualifications aren't up to scratch. Kylie gets to comment on those observations as part of the inspection, which I suppose is good. And she's got an explanation about the books. She says, yeah, we don't have as many, but we go to the library every now and then. And she compares her centre to another centre down the road that actually has fewer books, but passed its inspection. She gets hit with a notice of non-compliance, and part of the problem, so they say, you don't have enough resources, your staff aren't educated to fix it. You need to buy 400 more books. You need to get your staff to do professional development, and you have to suspend the provision of childcare services at your centre until you buy all those books. And Kylie's really worried because if she has to shut the centre down until she buys the books, she won't have enough money to actually buy the books, which is a bit of an issue for her. So that's the question. Let's start from the top. I said a few weeks ago, you know that the take-home paper is going to ask you 4 questions. The first is going to be about access to information. The second is going to be about whether judicial review and or merits review will be available. The third will be, if judicial review is available, what will be the grounds be? And fourth will be what are the remedies? So that's coming. Let's start from the top. Very quickly, because I know you guys kind of know this already, but access to information. What would we be thinking about? And Stephen's preempted me in the chat. Do an FYI on other centres and how they were dealt with. Yep. So we could ask for through FOI. We'd certainly be interested in that other centre down the road that passed last month. We'd be interested in getting stuff on their decision. Would there be any potential problems with that? Or would it be smooth sailing to get that information? Yep, so there'd be concerns with privacy, personal information, sort of the information of third parties. So we might not necessarily get it, but it wouldn't hurt to ask because that might help make our case in the long run, absolutely. In terms of, the reasons, maybe they're not quite adequate because they haven't really gone into much detail on the facts and the evidence, but we can skip over that because I know you guys kind of know that. Louise has made a good point about you could redact particular information if need be. So you could ask them to release kind of the reports of similar sized childcare centres or something like that, but actually redact just which centres they are. That'd be a good way of doing it. Amy says that we could argue that it's in the public interest to release it. We could do that, especially if, if we're sort of saying we might be about to uncover big problems with the decision making in this department and it's in the public interest that we get to the bottom of this. Yeah, you could try. Yeah, so Stevens points out as well that, this is a process that takes time and the centre would be shut down in the interim, of course. We're sort of potentially there's, yeah, there would be a time delay, but I suppose we could be doing this in parallel to some of the other stuff to try and get the centre back up and running. Cad's made a good point as well. I'm confused. Where does it specify how many books per child is required in early learning? It probably doesn't. It's sort of for the purposes of the facts, we can kind of assume that somewhere within the early years framework that the childcare authority is going off, that there is some kind of standard benchmark number for number of books. I didn't want to bore you guys with too many details of childcare frameworks and things like that. But, obviously that would be a very relevant question is, what's the basis? What's the authority to decide whether 200 books is enough or not? In the exam or in the take home paper, I should say, you guys will have more details provided. So you don't have to worry about, you know, sort of gaps in the facts like in this set of facts. So yeah, it's a good point, but we'll try not to get too bogged down by it this time around. So access to information, you know, we'd like to sort of get a better picture of what's going on in other childcare centres is probably the main avenue that we'd like to pursue. Excellent. Is judicial review available or likely to be available in this instance? Again, I think we can probably whiz through this fairly quickly because hopefully, you know, you guys are on top of this already, and this should just be a useful sort of revision for you guys at this point. So decision of administrative character made under enactment and not excluded. Awesome. So, you know, we've got a decision here. The direction, the non-compliance and the directions, it's administrative because it applies to her and not everyone. Made under an enactment, it's the Act, Section 6, Section 7, whatever it says, and it's not excluded. Will Kylie have standing? Yeah, right. It's clearly affecting her commercial interests in the business. Nice. All right. Cool. Let's get on to grounds of review then. What's leaping out to us as being a potential grounds of review? So Bothwell said, by telling them to stop providing childcare services, it was a disproportionate exercise of discretion. And quoting Justice French was like using a sledgehammer to crack a nut. Very nice. So unequal treatment that's unjustified as well, potentially. A few people picking that up in the chat. Awesome. So we've got thinking about the sort of categories or the paradigm cases that Justice starts with G. Gummo said in Fair's Rural Meat, the potentially got a capricious use of power here, and would also have got unjustified, unequal treatment. So let's talk about unjustified, unequal treatment first. What's going on here? What are we sort of pitching as the argument?
The daycare down the road was of similar, it had similar grounds. It had less books, but had around the same amount of children, and it passed its inspection. Yep.
So what we're sort of, the first step is to highlight the unequal treatment. And in this case, we're saying, you know, here's a very recent decision. This centre down the road had fewer books, but similar number of children. So it was, you know, the sort of the ratio of children to books was probably quite similar. Well, better in Kylie's case. So, and they passed, and yet she doesn't. So that's clearly highlighting the unequal treatment. And then sort of the second step is to demonstrate that that unequal treatment is unjustified. And so here, what we'd be doing is we'd be really pointing to these are two similar centres. And as far as we can tell on the facts, there's no reason to treat them any differently. And the key sort of thing when you look at the sort of things that the decision maker can have regard to in relation to number of kids, number of staff, all that sort of stuff, we're sort of drawing parallels between them and saying, look, there's nothing based on all of these things, there's nothing to justify sort of penalizing Kylie's centre. So it's not justified and therefore unreasonable. Cool. And yeah, some points in the chat sort of echoing that as well. Unequal application of the rules in relation to the number of books required. So yeah, so it's sort of it's kind of twofold in the sense that not only is she, you know, being called out on not having enough books when she's got more than the other place, but then there's sort of the direction that she's been given is that she has to go and get even more books, which yeah, it just blows the sort of the unequal treatment even further apart. Yeah, absolutely. So Louisa said if they go to the library and have a record, perhaps they can show that it wasn't factored in when the decision was made. Awesome. Yeah. So, and this comes to my point about, unreasonableness tends not to happen in isolation. You could also make the argument that this was a relevant consideration that the decision maker failed to account for, right? Was that, they didn't look to this sort of separate point about, they go to the library every week. They've got even more books to look at. Isn't this great? Surely that should have factored into the decision as well when looking at the learning resources that are available to the children in this centre. So, that's another ground of review, and we can talk about that a little bit more later if we want to. Should he not have provided a time frame for compliance? Yeah, probably. I mean, this would be the kind of thing as well that the Act would say if a time frame needed to be put in place. I think we'd fall short in an argument for unreasonableness, or the other direction you'd potentially go down is the decision's not authorized because there's no authority for it because the proper procedures not followed, is sort of the other way we could take that argument. We'd run into problems though because, well, for one, we don't know if the Act says a time frame or not, and then the other thing is that because there's sort of the point number 3 about you have to suspend childcare services until you comply with number 1, there is sort of a time frame there in the sense of, this is pretty significant, you better act quickly, or you can, take forever to do it and it will punish you, kind of thing. So there's, can see where you're coming from, but we probably wouldn't quite make it up in this instance. Let's move on to the sort of the capricious use of power, and then we can come around to Gory's point as well about no plausible justification to suspend the childcare centre, because that's kind of related as well. Let's talk about the capricious use of power. What's going on here? What's the argument? Where are we kind of going with this one?
So it's related to the purpose. So if the decision maker, I think, was using their power outside of what the purpose is. So the Act doesn't say, I think it doesn't proceed upon the hypothesis that the Commissioner will be motivated in the exercise that their powers by improper or collateral purposes from Edelsten. So if the Act doesn't mean, yes, you can make this decision if you're going to go off on your own little tangent and do whatever you want to do, basically, you still have to stay within the purpose.
Yep. Awesome. Anyone else wanting to add to that? If the centre's suspended, the kids will not have access to any books. Yep. So it's sort of, would you rather them have 200 books or no books? There's sort of an element of that as well. Yep. Anyone else?
Because if the purpose of the Act was to encourage the curriculum, like to introduce the curriculum and everything, if the kids aren't there, and then it's completely gone against the purpose by shutting down a kindy where the kids, like Stephen just said, they have no access to anything then. So the curriculum, the whole purpose is thrown out the window.
Mm-hmm. Yep, absolutely. So impact on staff as well, because, if the centre's closed, they, might either not get paid, or as the centre loses money, get let go of, or things like that. And yeah, so looking at sort of the impact of how serious having not quite as many books is compared to, the I suppose the punishment doesn't fit the crime, in the sense that they've got some books, and they actually have quite a few books compared to some other centres. That doesn't seem to be that problem, if it indeed it is a problem, doesn't seem to be in proportion with the punishment, which is, or the direction, which is close it down until you get even more. And so you're all absolutely right, and you string all these points together to say that the direction doesn't fit with the issue. It's not proportionate to the issue. It is a sledgehammer to crack open a nut, and then not only is it itself just not in proportion, but the run-on impacts in terms of denying children access to any learning, any books, that sort of stuff is it all sort of adds up to point to this being a real problem, and pointing to sort of the situation in Edelston, where it's like, the point of the power is to, ensure that childcare centres are doing the right thing, and to get them to lift their game when they drop the ball. The purpose of the power is not to utterly destroy the business and completely obliterate the provision of childcare. And so here we're seeing that Directive 3 is just is unreasonable, is what it comes down to. The ratio to the number of children at the centre, 100 books, seems reasonable. Yeah, probably. I mean, I wouldn't probably get drawn into a conjecture on the facts about what a reasonable number of books would be, unless there was something in the facts that really sort of drew you into it. If I don't know, the facts gave you some kind of, policy guidelines or a report or something, or, a recent academic study showed that children should read 50 books a year or something, like, if there was stuff on the facts that would sort of lead you to that, you probably could make that argument. But without that, it does become, I suppose, a little bit speculative. And it's something, I suppose, that's worth keeping in mind for the take-home assessment as well, is that you're not going to be required to go off and do any extra research. Everything you'll need will be either in sort of the facts that you're given, or in the unit materials, in terms of, provisions of the Administrative Decisions Judicial Review Act or things like that. You're not going to have to go off and, for example, research how many books kids should have access to, or anything like that. Some other points in the chat: could the law regulating the minimum requirement of books potentially be a constitutional ground of review? Yes, potentially, but I'm gonna drop one other hint, which is not one of these three hints. This is just another hint. Even though constitutional law is technically a prerequisite for this subject, I'm not allowed to test your knowledge of constitutional law. And so even though there might be a sort of a constitutional challenge to things, and I've mentioned this in, I think it was week 7 when we talked about unauthorized decision making, how a lack of an authority that's unconstitutional therefore becomes an unauthorized decision. It's a really creative path to go down, and I like the thinking, but I can't ask you that, so not relevant for this scenario, and also not going to be assessed for the take-home paper. And I've included a line in the take-home paper that specifically says, you don't have to worry about the Constitution. And I actually spell out what the potential constitutional argument would have been in that scenario, just so that hopefully none of you are led astray by thinking down that path. So great point. Thanks for raising it, but not necessary for us to delve into in this instance. Cool. Okay, so we've talked about unequal treatment. We've talked about capricious use of power. Was there anything else about capricious use of power that anyone wanted to talk about or raise? Cool. Alrighty. Well, let's then circle back to looking at a lack of plausible justification. Where would that stem from? How would we make that argument? Because that's potentially a little bit trickier than the other two grounds to make out. So there's the failure to take into account relevant considerations as sort of a separate ground of review that we've talked about. And so are you saying, Tammy Lee, that we would also use that to say that there's no justification for this decision as well?
Yeah, so it's sort of like the Justice Mason's cautions in Pico Wallsend, how he actually mentions it in there that that it could be, there's a fine line or a blurred line or something, I think, between the two, because if they fail to take into consideration the relevant considerations, then, and that's what they base their decision on, then that decision could then consequently be unreasonable.
Mm-hmm. Yep. So that's, I think that's part of it, and that's a good approach. Is there anything else that we could add to that or use alongside that? So talking about Parramatta City Council, Chief Justice Gibbs took one centre into account, but not the other. Yeah, you could. I suppose the thing that's tricky about the lack of plausible justification, or the hurdle that we have to overcome, and not to say it's an insurmountable hurdle, but one that needs to be recognised, is Section 7(3)(e). The Childcare Australia official can include any of the following actions, and then E is any other action reasonably necessary to address the notice of non-compliance. So that's really quite a broad set of discretions. And from an unreasonableness perspective, that's tricky for us, because that would sort of lead the court to be quite deferential to the decision maker about, where things need to be where they need to go. But as Tammy Lee said, the key part of that phrase is reasonably necessary. So we're arguing that it wasn't reasonably necessary to shut the centre down. As we've said, it's capricious use of power, and also on top of that, we're saying that there's no plausible justification for it, because it's just really hard to see where, I suppose, the two things kind of match up. Not having enough books and shutting the entire centre down, they just don't quite align very well. It's not reasonably necessary in the sense that it's hard to see how one helps with the other. And we sort of talk about that in addition to the other points that we've raised in terms of, failing to account for the library books as well, and all that sort of stuff. And so I guess what I'm saying is that it would be really important. A really good answer here would identified that sort of paragraph E as just upping the bar a little bit more in terms of how far we need to go in demonstrating unreasonableness, especially the lack of plausible justification element. And I think we would still, we'd still be able to do that. We'd still be able to meet that bar being raised a little bit more, but a really good answer would be able to identify that, say that the bar has been raised, and then go about showing how you meet that standard. Limited by section 6 as well. So the directions to the non-compliant childcare centre, the officer can only issue those directions if they've found the childcare centre's non-compliant in relation to one of those sort of areas, size of the childcare centre, number of staff, all that sort of stuff. And so what we're saying here, I suppose, is that the lack of plausible justification comes from the action under E. There's a link in the sense that it says, well, you can do any action reasonably necessary to make sure that they overcome the problems outlined in section 6. They've done that, and we're challenging the sort of the reasonably necessary part and saying that it's not, there's no plausible justification for it, because even though there is a connection, it's it's a bit of a long bow to stretch. Potentially raising an argument of why the act was made, perhaps a lack of food, not books. I'm having a little bit of trouble following that one. So are you sort of saying that the purpose of the act in terms of making sure that childcare centres are implementing the early years framework properly and stuff is more related to sort of the well-being, sort of the overall well-being of children, rather than necessarily in relation to the harsh penalty? Yeah, you could and I mean, I wouldn't expect it in an answer, but in practice, sort of one strategy for getting to highlight the unreasonableness would be to sort of get parents of children in the centre to get together a bunch of statements to sort of outline the impact that this will have on them as well, to sort of highlight, okay, well, the centre being closed for however long, perhaps indefinitely, is going to impact us in these ways. My children, really love reading books at this centre, and we don't have any books in our house, so now they're not going to get any resources, stuff like that. So yeah, you could gather together a selection of testimonials from parents and use that to highlight the harshness of the penalty as well, to show that it's unreasonable. Yeah, that could be one way of doing things. Absolutely. Any other questions or comments in relation to that one? In a reasonable answer, would you expect some analysis of a possible government response? I would expect that a good answer that showcases a critical appreciation of the facts would be able to pick up counter arguments that are sort of obvious, or the facts kind of point you towards it. And so, for example, with the midterm assessment, sort of the facts sort of led you towards this COVID document as being the sort of employment report as being something that would be good to get under FOI. And then the facts also really push you to comment on, well, Centrelink will probably try and argue that it's a cabinet document and it doesn't have to be disclosed. And so, you were sort of expected to identify that in the answer and be able to argue against that. So a good answer I would expect would be able to preempt and rebut some of the counter arguments, but the guide to that is there something in the facts that pushes you towards that, right? Like I wouldn't be expecting for every single point a massive back and forward over everything. You should be guided by the facts in terms of if the facts, point you towards, let's say in this one, let me have a look. So let's say
maybe if I could assist maybe with a question that I've been thinking of.
Yeah.
The unequal treatment argument, unequal treatment will not always lead to unreasonableness. And in this case, the government could argue that it was the combination of the lack of training over 10 years and not enough books that gave rise to the notice, as opposed to the centre up the road. They have more staff and they've gone over and above with their training, so they don't need as many books.
Awesome.
But that hole isn't really filled in the question here. It wouldn't be until you got some FOI information back. How would we treat something like that in an answer?
You'd well, for one, the take-home paper will be more, I suppose, obvious isn't the right word, but there won't be those same kind of holes. If there's facts, if there's facts that you need to know, it will tell you them. And so, if I was chasing for, this center is different, these centers are similar in some way, but there's one thing that makes them different that might potentially justify this unequal treatment, you would get given that in the facts, or the facts would point you towards that being a really kind of a potential thing. I wouldn't be, you can speculate a little bit and sort of say, this flagging this as a potential issue down the road that we need to be aware of, but you wouldn't be expected to, really go far down that rabbit hole. It's only if the facts sort of push you into the rabbit hole that you need to go down it, kind of thing. And the reason for that is that, I can only allocate marks to things that are there or that need to be there. And if I'm asking you to, speculate, you guys could all speculate in a million different directions, and it's, hard to create a consistent marking template for all those different directions. So, if the facts are pushing you down a rabbit hole, go down it. If they're not, you can let me know that the hole's there, but you probably don't need to dive down it too much. Wouldn't teachers have to re-register? Yeah, probably. And I mean, again, that's probably the kind of thing that is potentially relevant, but it's not on the facts. That sort of stuff isn't there. It's not provided for. I'm not expecting you to go outside of, what the material that you're given to look at, what are the registration requirements or the the professional development requirements for childcare teachers and things like that. So it's, it's a great point, but in terms of the answer, it's probably not, I wouldn't be expecting that or necessarily looking for that. All righty. Any other final questions, comments, concerns? Sorry,
I was just going to say the decision to suspend the trading was only based on until the first thing was met, not the PD. So whether or not that was because Kylie had already conceded that PD was necessary anyway. But so it was only actually on the basis that they get those books that that's why they're closing down until then. Once they do that, even if they haven't done their PD yet, they still can trade.
Mm-hmm. Yeah. So there's, and that I think we'd still probably have a strong argument that the decision as a whole is unreasonable, but potentially that becomes, a point in favor of reasonableness, is that, they haven't also made them stop until all the PD's done as well, or something like that. So yeah, potentially relevant as well, and could be mentioned, but it's still, I think we'd still have a pretty strong case that it's unreasonable. Okay, I can see one more person has completed the survey in the last hour, so thank you to whoever that person was. Thank you all for coming along. That's it. That's it for grounds of review. Next week, we come back to talk about remedies, and then that's the last of the substantive material for this unit. So well done. We're nearly there. Hang in there for a couple more weeks, and I'll see you all next week. Bye.